Hearing the appeal Williams and another against London Borough of Hackney.
Yes. My lords, my ladies, good morning. I appear in this matter, as the court knows, on behalf of the appellants, Mr. and Mrs. Williams, and I appear with Miss Cooper and Miss McGlynn. Mr. Stewart, Queen's Counsel, appears with Mr. Sinai on behalf of the respondent, which is the London Borough of Hackney. Also present are two interveners. Firstly, Mr. Toomey, Queen's Counsel, appears with Mr. Lang on behalf of the Association of Lawyers for Children. And Mr. Verdon appears with Mr. Edwards, Miss Kumar and Miss McGuinness on behalf of the Family Rights Group. The court also has written interventions from the Quorum Children's Legal Centre prepared by Mr. Geeky, Queen's Counsel, and Miss Siegel, and on behalf of the Equality and Human Rights Commission prepared by Miss Goulding, Queen's Counsel. The issue, as the court is aware in this appeal, is the operation of Section 20 of the Children Act 1989. The court is asked to determine what is the correct interpretation of the provisions of Section 20 and how they are to be applied in practice. And in particular, the question which arises in this appeal is whether it is necessary for a local authority to obtain the agreement of parents or those with PR, if they are parental responsibility, if they are not the parents, when it is accommodating children under Section 20 of the Act. And that requires the court to look at whether the obligation to obtain parental agreement is triggered by the parent's entitlement to object to their child being accommodated by the local authority or to remove their child from local authority accommodation. In other words, the interplay between Sections 20 subsection 7 and Section 20 subsection 8.
It clearly can't be a universal requirement to obtain agreement because those with parental responsibility may be nowhere to be found or dead.
Quite.
Existent. So it can't be a universal requirement.
Quite, and that, of course, was my lady's point all the way back in 1991 when my lady was commenting on the Act when it first came into force. And we will address that in our oral submissions, but the issue that arises is when a parent is actively parenting a child and that person is a holder of parental responsibility, as was the circumstances in the instant case. What is the nature of the local authority's obligation? It is our case that the children were, in this case, unlawfully accommodated by the local authority. And the court will be aware that this appeal arises in the context of a claim under the Human Rights Act 1998, the essence of which, or the focus of which, was the parent's claim that the accommodation was unlawful. It is our case that the parents objected at the time and that objection was valid, but also that they sought to remove their children from local authority accommodation 2 days after the police protection expired, and that was communicated in writing to the local authority 6 days after the police protection expired. So we'll go on in our oral submissions to look at those matters in more detail, but by way of opening, may I just outline what we say are 5 propositions of law that are central to our case and that form, if you like, the pillars of the appellant's case. First of all, we say that while a local authority does have a duty to accommodate children, which is set out in Section 21, subsection C in particular, that duty is not a standalone duty. It is subject to limitations. Secondly, we say that the accommodation of children by a local authority under Section 21, subsection C, or under Section 20, subsection 4, is a voluntary arrangement or agreement between the local authority on the one hand and the parents or the holders of parental responsibility, who in the majority of cases will be one and the same. Our third proposition of law, which is central to our case, is that before a local authority provides accommodation, it has to satisfy itself as to whether or not the parent or the holder of PR objects. And that is the obligation that arises under Section 27. The fourth proposition that we make is that the voluntary arrangement or agreement ends if the parent or the holder of parental responsibility withdraws their agreement. They are entitled to remove the child or the children, and that, of course, is Section 20, subsection 8. And the last proposition, which is fundamental to the understanding of Section 20 and the operation of Section 20, is that the local authority does not acquire parental responsibility for a child who is accommodated by it under Section 20. It remains at all times with the parent or the holder of parental responsibility. And ultimately, we say that that is the fundamental difference between the voluntary arrangements, which are at the core of Section 20, and the compulsory arrangements which are to be found elsewhere in the Act. In our submissions, we will track, as it were, along what we have set out in our written case, because we say that these 5 core propositions are supported by reviewing, first of all, the evolution of the concept of voluntary accommodation through the predecessor legislation, the 1980 Act, and into the Children Act itself. So we'll take the court through the evolution of the concept of voluntary care. A second factor that we will want to look at is the intention of Parliament at the time of drafting the legislation, and that will take us into the White Paper and the parliamentary debates at the time. We will also look at the Act itself, because we say that obviously Section 20 needs to be considered within the scheme of the Act as a whole. And then we will move on to look at the guidance, which we say is an overlay to the interpretation of Section 20. And we will look also at the interpretation and the guidance which has emerged from judicial decisions at first instance and at appellate level. Before looking at the evolution of the concept, I want, if I may, just to run briefly through the facts in the case and to draw the court's attention to a number of facts which are particularly relevant and important. Obviously, the facts are set out in the Statement of Facts and Issues, which you will find in the core bundle, MS 2720.
Sorry, give me that again, please.
MS 2720.
Thank you.
Now, the events with which the court is concerned in this case took place between the 5th of July and the 11th of September 2007. Mr. and Mrs. Williams were and are the parents of 8 children, and at the material time that the court is concerned with, the children were aged 14, 12, 11, 9, 7, 5, 2, and the youngest child was 8 months old and was still being breastfed. The catalyst for the local authority's involvement with the family was what Sir Robert Francis described at first instance as a relatively trivial incident. The second oldest child, who was then aged 12, was caught shoplifting, and when he was spoken to by the police, he made an allegation of physical abuse against his father. That led the police to attend at the family home on the 5th of July, and when they attended, the flat in which the family were living was found to be in a poor state, and as a consequence, the police invited the local authority to assist it to initiate a process under Section 46 of the Children Act and took the children into police protection. We'll look at that provision of the Act in due course, But for the purposes of outlining the facts, the court will know or need to know that police protection arrangements last for 72 hours, and that's obviously crucial in this particular case. Both parents were taken to the police station and interviewed, and they were released at 4 o'clock in the morning. And at the time that they were released, the police imposed police bail, and attached to police bail was a condition that the parents could not have unsupervised contact with the children. Now, in the decision at first instance, Sir Robert Francis found that the bail form, which included the conditions, was unsigned, and there was a note on the form to say that the parents were incapable. And the reference for that in the factual statement of facts and issues is MS 2927. The parents then, Mr. and Mrs. Williams, attended at the local authority offices on the morning of the 6th of July, and they met with a Miss McLaughlin and a Miss Toll. They left the local authority offices and went home to clean the flat, and they returned to sign an agreement at about noon. The only document that we would invite the court to look at this point in relation to the facts is the agreement that the parents signed on the 6th of July. And that is in the core bundle at MS 2970, Appendix Part 1. Now, there are, you will see that the agreement at MS 2969 and 2970 is to some extent unclear as to its purpose. And we would make a number of observations as to that agreement. Nowhere in the agreement does it set out what the information or what information was provided to the parents. Nowhere in the agreement does it state that the parents had explained to them or that they were told that they had a right, as it were, to object to the accommodation. And a reader of this document would not know whether that was an issue that came up in the conversation between the parents and the local authority. The agreement also does not record that the parents are entitled to remove the children from local authority accommodation at any time. And two further points which we say need to be drawn to the court's attention. If one looks at the bottom of page 2969, you'll see that the document states that all the children will remain in their foster placements for the present time. So that is somewhat lacking in precision as to how long the local authority, or indeed the parents, understood the agreement may be in force. Further, if one looks at point 5, you see there the provision that the parents will continue to comply with Hackney Children's social care. And it's very difficult for a reader of that document to understand exactly what that means.
Do we know if this is a standard form of agreement used by Hackney at the time? Or?
It's our understanding that this is the type of agreement that was used by Hackney. We will see also, my lord, when we look at some of the authorities that we want to take the court through or to, in a case called Re W, Lord Justice Tomlinson remarks on shortcomings in a Section 20 agreement, which seems, from reading the judgment, to have similar deficiencies to this agreement.
Was there any model of the sort of document that might be put to parents in the original guidance under the Children Act?
Not that we've been able to find. My lady will appreciate that there's a a spectrum of crises that lead to children being taken into Section 20 accommodation. What is one's experience is that there will sometimes be handwritten documents which are prepared at the home of the parents or wherever it is that the children are being collected from. What is interesting, we say, about this document is that it is a document that the local authority had time to prepare. It's a typed document. It includes the names of the children. And the local authority had, we say, time to modify that document to reflect the factual circumstances. It doesn't give any indication also, and I'll come back to this in a moment, but it doesn't give any indication that in the initial discussions, the parents, for example, were told that but for the bail conditions, the children could return home. It's entirely silent as to whether that discussion took place, and it's entirely silent as to, if you like, what it is that the parents are required to do so that the children can return to their care. One other point which we would draw the court's attention to, and I think it is something that is developed by the Family Rights Group in their knowledge inquiry, and it speaks to one of the difficulties that they identify, which is the concluding paragraph, which says that the local authority will seek legal advice with a view to protecting the children if it's found that the parents are not complying with the contents of the safeguarding agreement. Now, in some ways, that document is both downgrading the relevance of the agreement by referring to it as a safeguarding agreement, when, in fact, at the time, it was intended by the local authority to evidence the parents' agreement to Section 20 accommodation. But secondly, it's an example of what Family Rights Group refer to as compulsion or coercion, where parents are, as the parents in this case were, told by the local authority, if you don't agree to the accommodation of your children, the children will be in local authority care by virtue of a care order, an interim care order.
Ms. Fottrell, speaking for myself, I have some difficulty with this complaint about coercion and compulsion. It's the reality of the matter in many of these accommodation cases that if the children are sought to be recovered by the parents, legal proceedings for care orders will take place. And so for that to be explained to them, and then a complaint to be made that this is coercion, is something I have difficulty with.
Well, my lord, the point which is being made in relation to coercion, and I'll come back to it if I may in more detail.
Of course.
But the point that is being made in relation to coercion is that if parents are not properly informed as to the consequences of the agreement that they are signing, in other words, that your children will be in the care of the local authority and may return to you in a short period of time, may not return for many months, so that the objection that they make or the decision not to object is an informed decision. That's one thing. But if parents are told either you sign up to this or your children will be in care anyway, that is the point in relation to coercion or compulsion. And the fundamental point on the facts in this case, which we will explore in our submissions, is it isn't always clear whether or not the facts are going to firstly meet the Section 31 threshold criteria. And that, of course, is a matter when one brings the matter before a judge, when it is examined by a tribunal. A local authority's case may or may not be proven at the point of the initial application, but also the important point, which we say was not prominent enough in the Court of Appeal's thinking, that the fact that you cross the Section 31 threshold does not mean that the children will necessarily be removed from the parents. And if one is going to engage in a process which is considered and is intended to be less interventionist than Part 4 proceedings, which is intended to be parents agreeing to children being accommodated, because that is necessary to assist them, to assist the children, to address whatever crisis or whatever issue has arisen in the family. That has to happen as a result of an informed decision by parents, and not parents feeling under the sort of pressure which Family Rights Group evidence, we say very robustly and in great detail in their knowledge inquiry, where they do not consider that they have an opportunity to contest the local authorities' read of the facts. And ultimately, for Mr. and Mrs. Williams, that was the issue, that they did not have the opportunity to contest the local authorities' read of the facts. And
I suppose it depends on the perspective from which one approaches this. On the one hand, it might be said that the parents should be alerted to the circumstance that if they don't consent and indeed cooperate with the local authority, that recourse to proceedings might be had. But I suppose you might say that if that is a necessary ingredient of the, or an element of the agreement, that should be redressed by making it clear to the parents that their consent is required. I mean, there's nothing wrong intrinsically, is there, with alerting the parents to the possibility that if they don't consent and cooperate, that there may be recourse to proceedings.
Well, that's precisely the point, that there may be recourse to proceedings,
Yeah.
and the consequence of those proceedings may be removal of the children.
Yeah.
There's a...
But it's not inevitable,
No,
and it wouldn't arise in every case.
no.
Right. And my lady, what comes through from the knowledge inquiry, but what also we say comes through from the evidence in this case, was that the parents were given the impression that removal was inevitable if they went to court. Of course, parents must understand that it is part of the structure or the scheme under the Act that one has this escalation of concerns which leads to decisions about the level of intervention, and parents must understand that. That's part of the local authority's responsibility. But that doesn't equate to sign this document and agree to your children being accommodated, or we will obtain a care order. And that is...
Well, that's not what the letter says. All
No.
it says is that they will seek legal advice with a view to protecting the children.
That's what the document says. Mr. and Mrs. Williams left with the very clear understanding that if they didn't sign the document, the local authority would obtain a care order. And interestingly...
Have we got findings of fact about
There
this
is
from the trial judge?
Yes, there is a finding from Sir Robert Francis that Mr. and Mrs. Williams believed that they would not see their children again unless they signed the document. And that is at paragraph 65 of the judgment. The judgment of Sir Robert Francis begins at, it's in Appendix Part 1, MS 2918. And the, forgive me, 2945, paragraph E. So it's 65, paragraph E. And you'll see there that Mr. Robert Francis was not satisfied that that was what the local authority deliberately intended to convey, but that is what the parents believed they had been told.
Yes, but if one's looking at a challenge to the local authorities' behaviour, I mean, it's not enough, is it, simply to say that that's what the parents believe. The efficacy of the agreement and its capacity to convey to the parents the true legal situation has to be judged objectively, does it not?
Well, my lord, I accept that, but the difficulty in this case was not just arising from that factor. The difficulty arose from what the parents were told about their entitlement to object, but that's a separate point.
Yes, right.
So in answer to my lady's question, where do we find a finding about what they were actually told in terms of the possibility, probability, inevitability of proceedings and a care order?
Well, my lord, there isn't a finding that they were told that it was inevitable that there would be a care order. But, my lord, interestingly, in the local authority's written case, the local authority makes the assertion that in reality in this case, and we'll come to this in due course, that in reality in this case there were two choices. One was accommodation under Section 20, or the other was a care order with removal of the children. And of course we say that that was not, to return to my Lord Wilson's point, that that was not inevitable. And one has to query the extent to which parents are making an informed decision if they are given to understand that you either sign this and your children are accommodated, or a court will decide that your children...
Sorry, what was the other alternative? I mean, those were two fairly obvious alternatives.
Return to the parents, I suppose. Is the
Forgive me?
What's the other alternative? My lord asks.
Well, the other realistic alternative
Yes,
on the
return
facts
to
of
the
this
parents.
case.
Return to the parents, but the statement that the choices were between accommodation under Section 20 or removal of the children under a care order ignores the fact that in order to obtain an interim care order, the local authority would have to satisfy the threshold criteria.
Yes, of course.
And secondly, that they would have to persuade a court on the balancing exercise that removal of the children was less harmful than the children remaining at home. And that's the...
But I mean, they were realistic. They had to take a view as to what was likely on the facts of this case. And on the facts of this case, as perceived then, that was quite a reasonable view, wasn't it?
Well, my lord, I'll come back to that if I may, because that is not a point that we accept. And secondly, at first instance, Sir Robert Francis considered the issue of the police bail and whether or not the local authority was entitled to assume that the police bail was an impediment or a bar to the children being returned to their parents. And a separate issue arises, and this is more a point for Section 28, but a separate issue arises as to whether that state of affairs continued throughout the period of accommodation, because of course the circumstances changed and the position of the parents changed in terms of giving notice of their withdrawal of agreement to the local authority.
I think your point on the letter probably resolves to this, that there were two stark choices adumbrated in the letter. One was the consent of the parents, and the other was, in the absence of consent and cooperation, a care order. And your point is that in order to be sufficiently informative and comprehensive, the third possibility, namely return to the parents, or the importance of their consent, should have been referred to in the letter.
Well, the whole of paragraph 65 is worth reading, isn't it?
Yeah.
Yes.
they basically weren't given a full and clear picture of what the situation was, what the legal authority was for the local authorities' actions, what their rights were, what the options were.
Yeah.
Yes, and of course, although there are separate points, it is a point that we made earlier when looking at the agreement initially, that it doesn't record there anywhere that the parents are entitled to remove the children from accommodation. And that if this is a document, taking it at its lowest, if this is a document which is intended to record the cooperation between the local authority and the parents, the cooperation is a two-sided exercise. It's not something which can be imposed on the parents or enforced against the parents by the local authority. And if they're not told and the agreement doesn't record that they are entitled to object and or that they are entitled to remove the children, it's the point that is made at paragraph 65, withholding information from the parents. Now, that may well be because in the context of the day-to-day decisions that are made by social workers, there may be a lack of understanding as to how cooperation is to be explored or how it is to be evidenced. But the reality is that the document itself doesn't record it. And Mr. and Mrs. Williams say that it's something that they were not told. May I just return then to the facts? There are a number of other matters I just wanted to flag at this stage from the factual history. The agreement, as we said, was signed on the 6th of July. The police protection ended on the 7th of July. And on the 9th of July, having made some changes to the home environment, the parents returned to the local authorities' offices, and this is in the Statement of Facts and Issues at MS 2722, at paragraph 6. They returned to the local authorities' offices and asked for the return of their children. So that's the first occasion on which they did that, 3 days after they'd signed the agreement. Then on the 13th of July, the parents formally withdrew their consent or agreement, and they asked for the children to be returned to them. And that was a letter from their solicitors which stated that they would give the local authority a period of 10 days to make arrangements and complete its investigations. But the document clearly says that they were withdrawing their consent.
Where do we find that letter?
The letter is, the summary of it is at MS 2785, and it is in Appendix 1, the back of the core bundle, just behind the agreement. It is the second letter, so it's MS 2973.
Ms. Fottrell, backtracking for a moment.
Yes.
You told us that on the 9th of July, the parents returned to the local authority offices and asked for the return of the children.
Yes.
I'm not sure that your summary does real justice to paragraph 68 of Sir Robert's judgment, which says that that's what they said. They said to him that they had said, but the local authority denied it. And Sir Robert felt in no position to make a judgment as to whether they had asked for the return of the children.
My Lord, that's a slightly difficult issue, because in their original pleadings, their defence pleadings at first instance, the local authority conceded that, or admitted that had happened. So if my Lord looks at the Statement of Facts and Issues,
Certainly.
2722, paragraph 6.
The appellant's evidence was that they attended the council's offices, etc.
Yes, and you'll see the second sentence. The children did not want to come home, and the council admitted in its defence at first instance.
The children did not come home.
Forgive me.
Nothing about what the children wanted.
Forgive me.
No idea what the children wanted.
Well, right, my lady, I'll come to that in due course. But it sets out there, the council admitted in its defence at first instance that the appellants were told by the social worker that they could not take their children home. So that, in answer to my Lord Wilson's...
But are you saying that, I mean, insofar as it matters, which it may not, are you saying that's not overtaken by what the judge found?
Well,
or failed to find?
Well, my Lord, what we say is that the local authority accepted that in its...
I know, but what's their position subsequently?
Well, this is an
Was that
agreed
concession
statement of
withdrawn?
facts, isn't it? I mean, that's
Right.
your point, isn't it?
Yes.
That we have to proceed on the basis that this is an agreed fact.
Well,
Yes.
that they admitted it at the time, but don't admit it now.
Well, they admitted it at the time that the
It's very
statement of facts and
unsatisfactory
issues
to a
was...
point like that,
Yes.
based on an admission in pleadings which hasn't been recorded as a proper finding. Anyway, there we are.
Thank you, Ms. Vautrel.
My Lord, the next occasion on which that matter was raised was on the 13th of July, and that is the letter at 2973. And you see there the second paragraph. This is a letter prepared by Mr. Reed's solicitor, that he's giving formal notice of his intention to withdraw consent. And sets out his proposal that the children would be returned within 10 days.
It's a typically good, responsible letter from Sternberg's, who are family law specialists, and we must obviously read the third paragraph as well as the second.
Yes.
Yes?
My Lord, it's probably helpful also to look at the first letter which Sternberg Reed wrote on the same date, paragraph MS 2972, so the page before that. Because in the context of the parents having limited information or understanding as to what they had agreed, and in the context of there being a factual dispute between the parents and the local authority, you'll see that the last paragraph of the letter from Sternberg Reed requests the local authority to confirm whether or not they will be initiating care proceedings. Which is not an uncommon approach from family law solicitors, challenging the local authority's decision to take the children into accommodated care, and dealing with the question of whether or not that is a proportionate or appropriate response. Returning then to the facts, on the 16th of July, the local authority had an internal meeting of a body called its Children's Resources Panel, and at that meeting the local authority made a decision that there was insufficient evidence to keep the children in care. And the question of the bail conditions and the lifting of or modifying of the bail conditions was raised at that meeting. And the reference for that is 2977, MS 2977. Then on the 23rd of July, there is a note in the local authority records, which is at 2982, that in order for the children to be returned, the bail conditions need to be resolved or changed for the children to return home as soon as possible. On the 31st of July, the local authority held a child protection conference, the outcome of which was that the children were not at risk of harm such as to justify their continued accommodation.
It is of some interest that at the panel meeting, it is recorded that the parents want their children back.
That is the consistent position of the parents from the
Yeah, well,
6th.
it's more interesting that the local authority understood that that was their position.
Right, yes. And then,
This is on page 2977. If you look at the summary update, dum-ba-dum-ba-dum-bum. All children were removed immediately to separate placements and the parents bailed with condition no supervised contact. They want their children back.
you'll also see that the local authority at that point in time had done a visit to the family home on the 18th of July, and the circumstances in the family home had changed considerably in terms of the presentation of the home. And you'll see in the decisions action required, the third box down says, talk to police, re procedure and bail conditions. That being a decision and action which the local authority was committing to take.
Sorry, which page was that?
It's 2977.
Thank you.
It's the meeting of the 16th of July.
Yeah.
That is then consistently the position. If one goes on to 2982, the same panel meets again on the 23rd of July. And you'll see there again, the summary and update records accommodation was initially agreed by the father, but he has sought legal advice and is planning on withdrawing section 20, that is in the box summary and update. And then decisions and actions required, bail conditions need to be resolved or changed in order for the children to return home as soon as possible. And the local authority then held a child protection conference on the 31st of July. And again, the outcome of that was firstly that conditions in the home had improved considerably. And you see the minutes of that begin at MS 2995. At the bottom of page 2995, it records the house was clean and tidy and so on. And the local authority's position coming out of that meeting was to, again, to effect the return of the children. Now, the children eventually were returned on the 11th of September, and the sequence that led to that was as follows. On the 3rd of September, following a conversation between a Miss Morris, and this is at MS 3010, you'll see there a series of emails between local authority staff, which begins on the 3rd of September with an email saying, I've been informed by the family that the police are willing to vary the bail conditions. They are just waiting for the go-ahead from us. That's an email from a Mr. Freitas to a number of people, including Miss Morris. And then the emails continue until an entry on the 6th of September. Sue Morris has arranged with the police for the bail conditions to be varied with a view to the children being returned. And the children were returned on the 11th of September, some 5 days later. It's not clear why it was that it took 5 days for the local authority to action the return of the children. But we say that a number of points can be made on that summary of the facts. First of all, the points that we made about the agreement in relation to the lack of information and the lack of clarity about the legal position of the parents when they were entering into the arrangement. Secondly, at a very early stage, these parents indicated, whatever their position was as to whether they objected at the time or not, they indicated clearly that they wanted their children returned home. A third point which emerges from the facts, which we say is central and we want to look at in further detail, is that although the local authority maintained before Sir Robert Francis and before the Court of Appeal that the police bail was an impediment to the return of the children, it's clear that there was a circularity in terms of the police relying on information from the local authority, and the local authority ultimately being able or capable of arranging for the police bail to be lifted.
Am I right in thinking that it's possible to apply to the magistrates to have the conditions of police bail altered under the Police and Criminal Evidence Act?
My lady, I think that the first request, I think, has to be made to the police, the officer in the case.
But is it section 47, subsection 1E of the Police and Criminal Evidence Act? Perhaps in due course somebody can come back on that.
May I come back to you on
It seems fairly crucial in this case
Yes.
to understand what are the processes, the formal processes for challenging police bail, and indeed what are the consequences of not complying with the conditions of police bail.
Well, my lady, I'll take the court to where Sir Robert Francis dealt with the second of those 2 points. But there's a fundamental point that the local authority has maintained throughout this case, that if an application was going to be made to lift the police bail or to alter the conditions or modify the conditions, that was something which had to be done by the parents. And technically and formally that may be correct, but what we see from the case is that the police bail was modified at the request of the local authority. And when, at an earlier stage in August, when the police were considering whether the parents should be rebailed, they were given misinformation by the local authority about the level of the parents' engagement, which led to the bail continuing. So the idea that the police that the local authority had no agency or role in the continuation of the police bail is problematic in this case, because ultimately it was at their request that it was lifted. And that is consistent, we would say, with the interagency cooperation that the local authority provides information to the police about the progress of the parents and the continued justification for the bail conditions. Now, there's a...
It goes rather further than that, does it not? Inasmuch as the local authority regarded the conditions of bail as an inhibition on the return of their children to the parents, then you might wish to argue that it was incumbent upon them to advise the police of the lack of concern that they have, so that this, what might be described as a technical objection to the alteration of the bail might be cured.
Yes, precisely. That point has to follow from the local authority's remarks and its action points, which are recorded at the meeting on the 13th of July. It's not recorded at the meeting of the 13th of July that the parents must make an application. It's recorded as an action for the local authority itself. And of course, on a practical level, it makes it's logical and it makes sense that the local authority would have that role of providing the updating information to the police. Because on the one hand, there is the police assessment of risk, and on the other hand, there are the conditions which the police encountered on their attendance at the home on the 5th of July, which were not present when the local authority made its visits on the 18th of July and on subsequent visits. So the continuation of police bail in a state of ignorance, if you like, is very problematic in this case, because
Well, there is, of course, a danger of falling into a bureaucratic black hole here, because the parents were being legally advised, and presumably they could have applied for a variation in the bail conditions on the advice of the solicitors, enlisting, if necessary, the assistance of the local authority.
My lord, there is correspondence between the father's solicitors and the local authority, in which the father's solicitors requested that the local authority would set out its view that the children could return home in a letter, so that that letter could be used to support an application for variation of the bail. And that is at MS 2987. It's a letter dated the 27th of July.
Give the number again, please.
Forgive me, it's 2987. And you'll see that the request is made there. It would be helpful if you could provide a short letter confirming that it is the bail conditions which are proving a major obstacle to the children.
Actually, it also says that attempts have been made by our criminal department to vary the bail conditions currently imposed.
Well, you can see at the top of the page that the police officer
He was on leave, helpfully.
was on leave.
Yeah.
There was also a child protection conference scheduled within the local authority for the 31st of July, and the police were awaiting the outcome of that conference.
Yeah.
And you'll see that the response to that letter is on the following page, 2989. Police officers were in attendance at the Child Protection Conference. Unfortunately, we are not able to provide the letter, as any application must be made by your clients. It's not entirely clear why that position would be taken, because it's the substance of the circumstances that the solicitors are asking the local authority to set out in the letter.
Well, I think your point must be is that the letter from the solicitors wasn't asking the local authority to make the application. It was simply asking for a letter which would permit the solicitors to make the application.
Yes, and in fact, there's a subsequent letter from them dated the 3rd of August, MS 2991, making precisely that point.
But as I say, I mean, it is slightly difficult in that you put layer upon layer of bureaucracy here, and it makes it all extremely difficult.
My lord, that's clear from the facts in this case, but it's also clear, without repeating myself, it's also clear that when the direct approach was made by the local authority, it did result in the bail condition being altered. So taking a technical position, as the local authority did, saying it is the responsibility of your clients.
But
Well, it's quite extraordinary to answer the question. We'd like
A letter.
We'd like a letter saying your plan is to return these children home because we think that's the right thing to do. For the parents then to be able to, and their solicitors, to be able to take along to the police and say, that's what the local authority thinks.
And the local authority writes back saying, we're not making the application.
Yeah.
I mean, that's not an answer to the query that was put to you.
Not at all.
It also doesn't line up with the action points agreed by the local authority in its own child protection conference, that it would take steps to modify the bail conditions.
Can I just ask, on paragraph 22 of the statement of facts, the thing that seems to have triggered things was the first appellant telephoning the council to say the police were willing to vary. Do we know how that came about, how it was that the first appellant
The
became aware of?
mother, Mrs. Williams, herself instructed solicitors, and they made a telephone call to the local authority, or to the police, forgive me, and were provided with information, or the answer that they got from the police was we need information from the local authority. So if my lord looks at the emails that I took the court to a few moments ago at MS 3009, you'll see there an email from a Mr. Freitas. I have been informed by the family that the police are willing to vary the bail conditions. They're just waiting for the go-ahead from us. That was as a consequence of an inquiry made by a solicitor instructed for the mother, Mrs. Williams.
I mean, that seems to be the thing that sort of broke the logjam. We don't know quite why it did.
It's a circular process throughout July and August.
Going round and round in circles, isn't it?
Yes.
Yeah, we won't vary the bail until you tell us it's all right. We won't tell you it's all right until they vary the bail.
Or until you make the application. It's your responsibility to make the
I
application.
mean, no, I'm trying to get at what broke the logjam, because
Yes,
clearly,
yes, yes.
at some point, someone had the nous to ring the solicitor, the police, and say, well, are you willing to release her? And they said yes, and then it was all sorted out. We don't know why that didn't happen before.
Yes.
Right, okay.
Well, my lord, the position that the local authority has taken in this appeal and in the proceedings in the court below is that it was the parents' responsibility. It was a police decision. They were not active agents in that process, and we say that that's wrong.
Was Sue Morris forgive me, I should know that from the SFI, but Sue Morris is a rather senior.
She was one of the team managers, as I understand it, and she, with a Mr. McCallum.
She seems to have got a grip.
She was involved at an earlier stage, but yes, the trigger for the email that we looked at a moment ago is an email at MS 3004. And you'll see that that is an email from Miss Morris. This is the local authority's correspondence about the provision of information to the police. And you'll see the last paragraph. If the view is that the children should go home, which was what the panel instructed, bail conditions should be lifted and can be. Miss Morris then on annual leave from the 24th of August to the 3rd of September. On her return on the 6th of September, we can see that she actioned that. That just fills the picture, or fills out the picture. My ladies and my lords, may I move on then from the facts in the case to look at the wider points in relation to the development of the concept of voluntary care under Section 20, because we say that is fundamental to the court's interpretation of how Section 20 operates now. And if we could look particularly at the immediate predecessor to the Children Act, that being the Child Care Act 1980, and the court will find that at Authorities Volume 6, tab 71. Now, just before looking at the detail of this Act, there are a couple of points to make about the operation of voluntary care under the 1980 Act. The 1980 Act allowed, as we will see, for a local authority to acquire parental responsibility by the passage of time and by an administrative decision of the local authority, which was referred to as resolution under the Section 3 of the Act.
Well, it was a resolution. The local authorities passed resolutions.
Yes.
Some of us remember that, and some of us remember having seen such resolutions.
Yes.
Sort of,
And
I think whatever.
My lady, the other, my lords, the other key element of the Act, which was the trigger for the reform of the Act, was the fact that in order to have their children returned from voluntary care, parents had to give 28 days written notice. So we find those two provisions in Section 3 of the Act. You'll find that at tab 71, MS page 2049. And the heading is self-explanatory, assumption by the local authority of parental rights and duties. And the consequence of it, of a resolution, is set out in the last paragraph on that page. The local authority may resolve that there shall vest in them parental rights and duties with respect to that child, and if the rights and duties were vested in the parent, on whose account the resolution was passed jointly with another person, they should also be vested in the local authority, jointly with that other person. Now, it was the recognition that that process, the process of resolution, was procedurally unfair and substantively unfair to parents and didn't involve them sufficiently in the process.
Do we have Section 1 of the 1980 Act?
My lady, we don't have it in the bundle, but we do have Section 2, which is the first provision that deals with the accommodation. So if I may pause for a moment, Miss McLynn has copies of that.
But before losing the section we were looking at,
Yes.
It's not an absolute, is it, when the resolution is passed? Because on some of the grounds, the parent, if they haven't consented, can force it, shortcutting through the subsections
Yes.
into court.
Yes, yes. But my lady, it was the transfer of parental rights by administrative action that was viewed as being particularly problematic in the context of the rights of parents and the rights of the family generally. So that matter, and then if we turn over the page to tab 72, MS 2052, you see there the Section 13 of the Act, which required at Section 13, subsection 2, subsection B, that a parent had to give 28 days' notice of their intention to bring the voluntary accommodation to an end. Now, my lady, shall I pause and hand up Section 2 so the court can see?
You've referred us to Section 13(2)(b). You know your way around this ancient act better than I do, but I thought really the crucial thing was subsection 4 of Section 3, which is where you get the power of the parent who served a notice. After 1 month of service, the resolution lapses.
Yes.
So I think Section 13 simply piggybacks on that, probably, Ms. Fottram.
My lord, it does, but of course the...
Is that wrong?
It applies to Section 2 cases as well as Section 3.
Well, maybe, but...
Yeah. That's very important.
Yes.
It's very important. Section 2 was receiving children in what used to be called voluntary care, which is now called accommodation under Section 20. They're roughly parallel. That's why I wanted to look at Section 2, because it's so similar to Section 20.
My lady, shall I hand it up?
Yes, but could I just finish what I'm saying first? And Section 13, 2b, requires the 28 days' notice from the parents to remove the children from Section 2.
Yes,
care.
yes.
And then there's on top of that, there is the power of the local authority to assume parental rights by resolution, which of course the parents can challenge. But there was research about the effect of that.
Yes. But, my lady, if we look at Section 2,
Thanks.
there are, as my lady, Lady Hale has observed, there are very significant parallels between it and the content of section 20.
May we have a copy?
Yeah, have this one.
Well, I
There's-
don't want to
I'm-
obstruct your lordship's reading of it.
No.
No, one's on its way. Thank you very much. Thank you for the kind offer, my lord. We have one. Thank you.
Yep.
Now, your point is that there were coercive elements in the previous voluntary care system, and you're presumably going to suggest that one of the objects of the 1981 Act was to 1989 Act,
My lady, it
was to get rid of those.
It was a growing recognition that these two provisions, particularly the coercive elements, the resolution and the 28 days notice, didn't strike the right balance, if you like, in terms of procedural fairness to parents. And in the review of childcare law 1985, which led to the white paper, which I'd like to ask the court to look at, there was a recognition of the need to rebalance those rights in terms of voluntary accommodation. So if we turn then to the white paper is in volume 7 of the authorities bundle, tab 83, and there are a number of provisions in it I would like the court to look at, which begin at MS 2155. And you'll see the scope and objectives are set out at 2155. And in particular, at the bottom of paragraph 4, it states that the prime objective has been to seek improvements in the law so as to offer a fairer deal to both children and parents, especially in the legal processes when compulsory state intervention is necessary to protect and promote the interests of the child. If one then goes on over the page to 2156, you'll see principles set out at paragraph 5. And we see there the voluntary accommodation referred to at 5B and C, and voluntary accommodation being referred to as a service to families in need. And then paragraph C, recording that the transfer to the local authority of parents' legal powers and responsibilities should only be done by a full court hearing following due legal process. So that, if you like, is the delineation between the voluntary and the compulsory. You'll see also at the bottom of page 2156, paragraph 8, there's the reference to the need to codify the law into a single piece of legislation. And then if one goes on to look at chapter 2 of the white paper, which is headed Services to Families with Children, that's page MS 2158. Of particular relevance, we say, is paragraph 20. And you'll see it records local authorities having a duty to receive children into their care in specified circumstances, generally when there is a need for the child to be away from home. This duty will be maintained. So will the duty to return the child to the family. Then it goes on in paragraph 21, the bottom of that paragraph, to record an essential characteristic of this service should be its voluntary character, that it should be based clearly on continuing parental agreement and operate as far as is possible on the basis of partnership and cooperation between the local authority and the parents. Paragraph 22 goes on to set out a number of proposals that we'll see appear in the legislation which modified the 1980 Act. And perhaps the most relevant for the purposes of our submissions is paragraph B, which is removing the set period of notice in relation to terminating the voluntary accommodation. Paragraph 23 records that where a local authority provides for the care of a child away from home, with the voluntary agreement of the parents, such matters as initial placement, schooling and access, and subsequent changes to these arrangements should be settled by mutual agreement. You'll see also at paragraph 24, it sets out that if there are occasions where a local authority is seriously concerned about the care of a child and agreement cannot be reached with the parents, in such circumstances, it's no longer intended for the local authority to assume parental powers and responsibilities. Instead, the local authority would be expected to seek a court order. And again, paragraph 25 continues in the same vein. Not always possible for the local authority to enter into agreement with parents, and that is the point that my Lady Hale raised at the outset, because the parents may be incapable or they may have abandoned the children.
I imagine that the most common example, people will tell me if I'm wrong, these days, would be unaccompanied asylum-seeking children.
In relation to B and A and B, yes.
In relation to parents not being able to give their agreement.
Yes, yes. And then one sees at paragraph 27, you see that there's reference there to the possibility of the voluntary arrangements breaking down, and the paragraph, halfway down the paragraph, it begins, the local authority responsibilities in respect of all these children require statutory definition. At present, where a child is cared for away from home under a voluntary agreement, the respective responsibilities of the parents and the local authority are unclear and can give rise to disputes over the management of a child's care, particularly on placement and access. This can lead to a blurring of the very real distinction between the position of parents of children in care under a voluntary arrangement and those who are committed following a court order. So, my lords and my ladies, we say that what emerges from the white paper is a clear intention to reform the legislation to remove those blurred distinctions between voluntary care and compulsion, but also to provide more clearly for the circumstances under which a local authority does take children into voluntary care. And what runs through the white paper, a thread that runs through the white paper, and we see it run through the parliamentary debates, and we say ultimately through the legislation, is that the essence of Section 20 is a voluntary arrangement. It is an agreement between the local authority and the holders of parental responsibility, where the holders of parental responsibility are actively parenting the child. Could I ask the court then to look at the excerpts from the bill, which you find at volume 7, tab 84. And those elements of the white paper, which we've taken the court to run through the discussion as to the drafting in particular of Section 27.
So what are you taking us to? What are you taking us to?
I'm taking you to the Standing Committee B debate, which is...
Well, on what basis are we looking at Hansard?
Well, my lady, there are 2 points that we wanted to bring the court's attention to.
Well, yes, but this court does not, no court looks at Hansard, parliamentary debates, unless the conditions laid down in Spaffholm are applied. And even then we probably don't. So
Well,
So tell me how it's admissible.
well, my lady, shall I make the following point, and I'll come back, if I may, to the question of whether we wish the court to look at the substance of these debates. We say it is very clear that the thread which runs through the white paper runs through the parliamentary debates in terms of the intention of Parliament to secure and to safeguard this voluntary element of Section 20.
Well, we have no problem with the white paper, because white papers are very good evidence of the mischief at which the legislation is aimed. But we are bound by authority as to the circumstances in which we can look at Hansard. And I merely wish to have it explained as to whether those circumstances exist.
Well, my lady, there is some suggestion from the local authority in its interpretation of Section 27 in particular, that there is ambiguity as to the meaning and intention of Parliament behind Section 20 around this question of willing and able in particular. Was that a matter which the local authority is entitled to determine if there is a dispute of fact between the parents? One issue which emerges, and it is only that issue that we wanted to draw the court's attention to, is the position of the government when introducing the amendment to the bill, that Section 27, the inclusion of willing and able, was to deal with a very particular factual circumstance. And that was where the one parent who was actively parenting a child, in the debate it's referred to as a single mother who was actively parenting a child.
Look, I'm still not getting what I need, because otherwise this is not admissible material. One needs an ambiguity in the legislation. You, I imagine, do not think there is any ambiguity. You presumably agree with the Association of Lawyers for Children's analysis of Section 20, which does not suggest there's any ambiguity, and you need a clear government statement that resolves that.
My lady, shall I move on?
Can I come in here briefly? In paragraph 25 of your case, you quoted what a government minister was saying about this matter.
Yes.
Speaking entirely for myself, I was interested in this, even though I may have been looking at it, as it were, improperly, Ms. Fottrell. You have already explained, without reference to what he said, that there was a bill and there was an amendment to the bill. And speaking for myself, I would, unless I don't think that's objectionable, be very interested to see the original terms of the bill, Section 20, subsection 7, and the amendment. And that, I don't think, could be objectionable. Equally, and I speak only from memory and may be wrong, does Pepper and Hart also entitle us to look at Hansard if we want to see what the mischief aimed at by a particular provision was? And might you be able to answer, my lady, by saying that it's the mischief of the aimed at by the amendment which you want the minister to explain to us?
Could I perhaps ask Ms. Fottrell?
Yes.
If you can go away and look at this. I'm raising the question because I want us to be absolutely correct about what we look at and what we don't look at in this connection.
Yes.
I'm as curious as my lord is to the answer to the question as to what the original bill said and what the purpose of any amendment was. That is true. But I need to be reassured. And we can certainly look at the legislative history, so we can look at what was introduced and what emerged. And it remains a question, and there may be an easy answer to it. I'm not suggesting that one way or the other.
Yes.
I'm merely anxious that we do things properly.
Yes, of course.
That we don't just slide into looking at parliamentary materials improperly.
So you've got the green light to show us the original bill, please, Ms. Fottrell.
Yes.
That is important.
Yes.
You have not yet got the green light to read what the minister said.
My Lord, may I just pause for one moment? My Lord, it may be helpful for us to return to this point in the context of addressing the issues raised by my lady, Lady Hale, but also the bill itself is not in the materials, but we do have it. So perhaps if we pause...
Maybe if we move on, but park the question.
Yes, if we park the question and return to it perhaps after the luncheon adjournment, we can deal with that as a discrete issue.
Good.
May we then turn to the Act itself. And we want to take the court through a number of aspects of the Act, because, of course, we say that it's fundamental to understanding Section 20 that we look at the entire scheme under the legislation. The Act is at Volume 6, tab 70, and it's manuscript page 2012.
I'm afraid it is a rather more prosaic explanation for MS. It's not manuscript, it's memory stick.
Yes, I'm aware that debate has been had in this
It's
court.
not a debate.
It's not a debate, I'm
Forgive
afraid.
me, I'm aware that matter has been clarified.
There's no question of it being a manuscript.
I'd rather like it to be manuscript, but I'm afraid it isn't.
I would certainly like it to be manuscript.
Yeah, but
But the one thing it clearly isn't, of course, is because it's
electronic.
It's electronic, so it cannot possibly be manuscript.
Shall I just use MS? Is that the easiest?
Yeah, MS or memory stick or electronic bundle or whatever.
As long as you give us the page. Which
Yes,
is
the page is
important thing.
2012. And the first provision of the Act that we want to look at is the provisions relating to parental responsibility, because, of course, a central concept introduced by the Act is parental responsibility, and the impact of Section 20 on parental responsibility is fundamental to understanding its voluntary nature. So if the court sees at MS 2012, you'll see paragraph 2 sets out the circumstances in which parental responsibility is acquired. And one then turns on to MS 2014, which is the meaning of parental responsibility. Paragraph 3.1 sets out that parental responsibility is the bundle of duties, rights, powers and responsibilities and authority which by law a parent of a child has in relation to the child and its property. And then an important point for the purposes of Section 20 is paragraph 3, subparagraph 5, which is the way in which a local authority, which is accommodating a child, is able to do what is necessary for the purpose of safeguarding or promoting the child's welfare.
What is reasonable in all the circumstances of the case?
Yes.
Which is a bit broader than necessary.
Yes. So, those are the provisions in relation to parental responsibility. Now, the crucial point, of course, is that parental responsibility is retained by a parent or the holder of PR when a child is accommodated. One has to look at Part 4 of the Act to see circumstances in which that is curtailed or limited by the local authority. And that is, first of all, by virtue of Section 31, an order which is made under Section 31. And you'll find Section 31 at MS 2028. That is the provision in relation to care or supervision orders. 31.2 sets out the threshold for the making of a care or supervision order, and I'll come back to that if I may in a moment. You turn over the page to section 33, you see the effect of a care order, MS 2033. Section 33(3) designates parental responsibility. The local authority acquires, I should say, parental responsibility for a child who is the subject of an interim care order or a care order. The other provisions under the Act which I would like just to draw your attention to briefly are Section 38, which you find at MS 2036. That is the provisions for interim care orders. And those orders can be made at any stage in proceedings where there is an application for a care order before the court. And the threshold criteria are as set out at section 31(2). And then if the court turns on to...
Well, the threshold criteria for an interim order are not that the conditions in section 31(2) actually exist, but that there are reasonable grounds for believing that they exist.
Yes.
As you might imagine.
As is keeping with the level and the nature of the inquiry that the court is in a position to make at that stage of the process. Then the next provision we would like the court to look at is section 44, which are emergency protection orders, and that's MS 2040. And these are limited in time, confined to very particular circumstances, and allow for the removal of a child. You'll see that at 44(1)A. And the applicant there is the local authority. Of course, within the scheme under the Act, if the circumstances of the attendance of a local authority, for example, at the home, are such that the children require immediate removal and the parents will not agree to that, the application process under section 44 allows for the local authority to seek the removal of the children and placement of those children compulsorily into its care. And then the only other provision that we'd like to draw the court's attention to, which applies in this particular case, of course, is section 46, which is the police protection provisions, and that is MS 2045. There's a couple of points to note about that. The test in terms of a constable taking police protection measures is that they have reasonable cause to believe that a child would otherwise be likely to suffer significant harm. It's a higher test than the local authority, say, applies under section 27, that a parent is not able to accommodate their child, or a different test. The police do not acquire parental responsibility for a child, and then the limitation under section 46(6), that no child may be kept in police protection for more than 72 hours, and that's MS 2046. Now, may I very briefly deal with the distinction between Part 3 and Part 4 of the Act before turning to look at Section 20 itself. We raised earlier, and there was some discussion earlier between the court and our submissions as to whether or not the local authority was right to say that the choice in this case was between a accommodation or a care order. And just for reference, that is in the local authority's written case at 2785. This choice was either to accept the continued assistance of Hackney while the investigations were taking place, or to have their children taken into care. And the difficulty...
Which paragraph, please?
Forgive me, it's page 2785.
I've got that. Yeah. Oh yes, it's paragraph 13.
Yes. Mm-hmm. The difficulty with that approach from the local authority is it's driven by either a misunderstanding or a misinterpretation of the process and the procedure under Section 31 and Section 38. And we make the point in our document that, first of all, the local authority has to prove to the satisfaction of the court that the threshold criteria are met, in other words, that the children have suffered or are at risk of suffering significant harm. That has to be based on the evidence that the local authority presents to the court. But also, and we say this is crucial in the particular facts of this case, but also that the court has to consider whether or not, even if the threshold criteria are met at the interim stage, whether or not removal of the children is justified. And if there, as we said earlier, is a dispute as to the facts, as to are the threshold criteria met, or should the children be removed as a consequence, that dispute has to be resolved by the court. Now, we refer in our document to a number of authorities which set that out.
Well, what do you say the alternatives, how do you say the alternatives should have been expressed by Hackney?
Well, Milo, the question is whether or not the children are accommodated or whether a court decides that the children should be removed. Those are the alternatives. The position is not that the care order follows from either the threshold criteria being met or from the court weighing in the balance whether removal is more harmful to the children than returning the children.
Well, on the basis of the premise that the parents had no proposals to make in respect of accommodation, if Hackney had said that the choice was either to accept their continued assistance or to face the prospect of Hackney applying to the court for a care order, would there be any objection to that?
No. The point here is that if the local authority are going to continue to accommodate the children against the express wishes of the parents at the point of providing or later, and there are factual issues between them, that matter has to be taken before the court.
Right. Okay.
That's our fundamental submission. And when one looks at it in the context of the facts in this case, apart from the procedural matters that we looked at earlier in relation to the procedure for the lifting of bail, there is also a question as to whether or not the consequences of the bail was that the children could not live with their parents, and further an understanding of the consequences of the breach of the bail.
Well, the consequence of the breach of the bail would be the potential for one or both parents to be arrested.
Yes.
And what would follow from the arrest? They might not get bail again. Well,
Marie, can I direct the court to where Sir Robert Francis dealt with this matter, and that's returning to paragraph 65. And this is a slight detour from the points we wanted to make about the interim removal and the legal test that applies. So this is in Appendix Part 1.
2945.
Bottom of page 2945. You'll see Sir Robert Francis recording that breach of police bail is not an offence, and there's no evidence enabling me or the claimants to know
what paragraph are you in?
I'm in, forgive me, 2944.
44.
Forgive me, 65B.
Fine. But didn't anybody talk about the theory of what could happen?
That is the previous page, paragraph 60, 2942. Police bail is granted under section 37. Conditions may be imposed by virtue of section 47, which I think was my lady's question earlier.
Right.
breach of the police bail entitles the police to rearrest. And then at paragraph 61, Sir Robert Francis goes on to note that breach of the bail would not be an offence. And his conclusion from his consideration of those provisions was the consequences of non-compliance would be most likely limited to a consideration by the police of whether to rearrest the parents. And then his observations that I took the court to a moment ago at paragraph 65b.
The reason I was asking about that at this juncture was because the local authorities case is, in a sense, I think, concentrating on the practicality of the situation. And I was trying to look right through to what the sequence of events might have been if the children had been returned in putting the parents in breach of the bail condition.
Yes, and Sir Robert Francis clearly considered that the risk of arrest was there. The consequences of it, he wasn't able to reach a concluded view. What is, in the context of this case, problematic is the assumption that because there was a condition on police bail that the children could not have unsupervised contact with the parents, that meant that the children couldn't live with the parents. And that is not always the case in circumstances where parents are operating under a police bail because there's been an injury to a child. It is possible for relatives and so on to move into the property and to undertake that supervision. It is also the experience of family lawyers and family courts that when one encounters the sort of situation that one sees here, where there was a toing and froing or a circularity between the local authority and the police as to whether the bail conditions could be lifted or should be lifted and what the local authority's responsibility was in that, that an application to court for an order sometimes is the catalyst for police attendance and clarification as to conditions and so forth. But those were matters beyond the consideration of Sir Robert Francis, but they do inform the general approach of the local authority that police bail was an impediment, full stop, in this particular case. Could I then just very briefly return to the question of removal at an interim stage? And I'll take this, if I may, relatively quickly because it is, we say, uncontroversial, and I'd like to give the court a number of references in relation to the balancing exercise that has to be undertaken when an application for an interim care order is made. Because in the circumstances of this case, that was crucial to the approach of the local authority to this question of the inevitability of the children remaining in local authority care, whether it was under accommodation or under a care order. An application for an interim care order where threshold is proven requires the court to look at the question of whether separation is necessary to protect the child's safety. And the authority for that is a case called Re-H, which is a decision of the Court of Appeal. It's at Bundle 2, tab 23. And the reference in terms of looking at it, I'm not going to take the court to it, but the reference in terms of looking at it is paragraph 39, MS 479. We say that's uncontroversial and it's established law. Similarly, when a local authority at the interim stage has care of children, whether that be by virtue of accommodation or another arrangement, there's an obligation on the local authority to review and to seek to justify continuing removal of children. And the authority for that is a case called Re-M, again, a Court of Appeal decision, and again, a decision of Lord Justice Thorpe. The reference for that is tab 25, MS 251, paragraph 23. And then lastly, in these cases, there is the necessity of weighing...
Sorry, what was the MS number again?
MS 251. That's the case of Riem.
Paragraph,
Paragraph 23.
you got it?
I'm not sure it's 251.
Yeah, it's
Two
also
five one.
I think it's more like 521.
521.
521. I think there's an inversion there. I think it's 521 is what.
Forgive me. Thank you, my lord.
Thank you.
And then the balance of harm exercise, in other words, that the removal of the child must be proportionate to the risk of harm that the child would be exposed to if they returned to the care of their parents. And again, a further decision of Lord Justice Thorpe, the case of Re B, tab 17, volume 1 of the Authorities Bundle, paragraph 17 at MS 351. And the test that's being applied there in that exercise is a welfare test. Is the welfare best interests of the child served by the child being removed or returned? And those authorities, we say, underscore the fact that in order to be convention compliant, where there is this dispute or this difference between the parents and the local authority as to the facts which the local authority relies on and the consequences of those facts justifying removal, the matter is to be adjudicated on by a court. These are the tests that the court has to apply.
Well, the point is the threshold is only a threshold, and the court then has to go on to consider whether, in all the circumstances of the case, including the checklist in section 1, subsection 3, it's in the best interest of the child to make the order.
And for the child to be removed or continue to be removed out of the family.
Well, it's to make the order, isn't it? And that has to be in the light of what the local authority plans to do.
Yes.
There are plenty of interim care orders where, in fact, the children stay at home, aren't they?
Yes, yes. But if the local authority in this case was going to justify its continued removal of these children, that is the exercise that the court would have had to undertake. And bearing in mind that at a very early stage, factually in this case, the circumstances had changed, and bearing in mind the experience of these children in care, the younger two children had 5 moves of placement, the older 2 children had 2. There is a compelling argument around the balance, where the balance lay in this particular case. Could I then turn to look at the text of section 20 itself? And section 20 is at volume 6 of the Authorities Bundle, tab 70, MS 2024. Now, if I can relatively quickly take the court through the provisions of section 20. First of all, section 21 sets out the duty of the local authority, and one can see from the way that it is phrased that it is that the local authority shall provide. And one also sees the evaluative element of the judgment which is being made by the local authority being set out in who appears to them to require accommodation. The points A and B relate to children where there is no person with parental responsibility, but the vast majority of cases where the issues of agreement arise are obviously in relation to paragraph C. Now, before coming back to look at what or how the court has previously interpreted paragraph 21C, may I very quickly just go through the other provisions in section 20. For the purposes of accommodation of children in circumstances similar to this case, the next provision that the court may wish to look at is paragraph 20, subsection 4. Because you'll see that the local authority here say the accommodation was section 21C, or in the alternative section 24, and that's MS 2025. That is a permissive provision. It says that the local authority may provide accommodation for any child within their area. But there is a difficulty, we say, in a submission that agreement is not required in relation to this provision, because, of course, the distinction here is that a person who has parental responsibility is able to provide him with accommodation. So that must, we say, invite an agreement requirement in order for that child to be accommodated.
I'm sorry, I don't understand how you get that from that provision. The local authority may provide accommodation even though, let us say for the sake of argument, a parent can provide the child with accommodation. Why does that connote the requirement of consent on the part of the parent?
Because the circumstances under section 21C relate to circumstances where the parent is not able or is prevented from providing suitable care or accommodation. In the circumstances of section 24, you have a parent who is able. And so the trigger is that the child is in need, and the local authority considers that it would be necessary to safeguard or promote the child's welfare. The parent is able to provide accommodation. It may be helpful to think about this in the circumstances in which it is most frequently applied or most frequently used. Section 24 is most frequently used for short stays or respite care for children with disabilities. And indeed, there is statutory guidance in relation to short stays or short breaks for children. And that is in the materials at volume 7, MS 2273. So before a child would be accommodated under section 24, you would have an assessment of need under section 17. The safeguard or promote the child's welfare is the language of section 17. The child is normally living with the parent. And section 24 accommodation is a intermittent short breaks.
You say that there'd be an assessment of need under section 17, but there's a difference between section 20 subsection 1, which is about any child in need,
Yes.
and 4, which is about any child.
Yes, but my lady, the exercise that brings a child whose parents are able to provide it with accommodation to the attention of the local authority, such that the local authority identifies that there is a necessity to safeguard or promote the child's welfare, is the assessment of need which the local authority carries out under section 17. Might it be helpful to look at the guidance on short breaks, because it explains it perhaps more clearly and eloquently than I am explaining it at the moment. So the guidance on short breaks is at volume 7. MS 2273. This is statutory guidance issued in 2016, I believe. And if one looks at 2280, you'll see the legal basis for short breaks set out at paragraph 2.3. Paragraph 2.1 says short breaks are part of a continuum of services which support children in need and their families. And then it goes on to list the types of provision that is made. Use of paragraph 2.2, most users of short breaks are disabled children and their families, but non-disabled children in need. may also receive short breaks. And then it goes on at paragraph 2.3 to explain.
Well, disabled children are automatically children in need, aren't they?
Yes.
Under section 17.
Yes. But the assessment would be the services that the child would require. And you see under paragraph 2.4 that there are two different legislative powers or provisions relating to short breaks, section 17.6 and section 24. And paragraph 2.5, local authorities should always be clear about the legal basis upon which services are provided. Their decision to provide a short break under section 17.6 or under section 24 should be informed by their assessment of a child's needs.
Will you submit that recourse to section 20, subsection 4 should only be had where there is a need for a short break?
No, I don't. I mean, I can't make that submission because that's not what the provision says. That is where it is most often used. It illustrates that it is used in circumstances where a parent is able, but a service is provided.
And where one would expect that the parent's consent is required. But there's nothing in the text of section 20, subsection 4, is there, which requires the consent of the parent?
Well, my lord, there's nothing in the text of section 20 anywhere that requires the consent of the parent.
Right.
It's difficult to contemplate circumstances in which a local authority could accommodate a child where the parent is able. And that being the terms of the subsection itself.
Well, it all depends how broad a view you take of section 20, subsection 1, paragraph C, doesn't it? What prevents somebody from doing it?
Yes. Yes.
Think of an example of a teenage child, but under the age of 16, who refuses to go home. Parent perfectly able to provide the child with accommodation and indeed possibly wanting to, but certainly able to, but the child refuses to go home. Now that's a situation which a local authority may very well, for a very short period, take the child off the streets.
Yes, but it doesn't negate the...
I'm not making any point about consent. I'm just making a point about sorts of situations in which section 20, subsection 4 might arise.
I can quite see that, except that, although my lady is not making a point about consent, in those circumstances there would not necessarily be consent. In other words, if the child refuses to go home, the local authority could have recourse to its powers under section 20, subsection 4 to safeguard the child's interest, but it wouldn't be a prerequisite to have the parent's consent, would it?
Well, I would say it would be a prerequisite to have the parent's consent.
Well, the parent could then come along under subsection 8, that's the point.
Or 7. I share Lord Kerr's surprise that you're trying to squeeze the consent / non-objection element into subsection 4. I would have thought it's plainly within 7 and later 8.
Yes, my lord, it is within 7 and 8, but the point that we were making, and forgive me if this is not clear, it is being said by the local authority in this case that the accommodation of this child or these children was either under section 21C or it was under section 24. And the section 24, we say, wouldn't apply in this case because the parents were able. Now, I recognise that that is a matter of dispute, and that takes us into section 27. I recognise that, but
I don't understand how you say that on the words, because it says that you can provide accommodation even though a parent is able. In that section, if you just look at 4.
Yes.
And they were able, but it doesn't matter for the purposes of 4. But if you view 1 to possibly 7, possibly 6, as powers and duties conferred on the local authority, and then 7 possibly, and 8 as powers conferred on parents or limiters on the local authority's power, then it starts to look slightly different.
Yes.
Because you don't then have to squeeze everything into, say, 4. But just going back to the terms of 4, it expressly says that it will apply, doesn't it? Even though the parent is able.
But, my lady, it's a discretionary power the local authority may provide. So it's a discretionary power which the local authority can exercise. And if one reads that, and perhaps if I take up my lady's invitation to read it together with section 27, if one reads that together with section 27, a parent who is asserting that they are able, or a parent who as a matter of fact is able, would have to give their agreement to accommodation under section 24.
No, just not object under subsection 7.
Well, my lady, that perhaps takes us to the point of whether the concept of objection requires agreement, but perhaps I can move on to that point in a moment. So to return to the provisions under section 20, before getting to the limitations, we set out that clearly there is the provision in section 21C, the provision in section 24, provision in section 23, and the provision in section 25. Now, in our submission, and I'd like to take the court through the previous authorities on this, but in our submission, there's a difficulty with an approach that when the duty arises, for example, under section 21, or if the discretionary power arises under section 24, that is a duty which the local authority can in any way enforce. And it's clear from the wording of the Act, it's clear from the interpretation of section 21C particularly, that the local authority is required to provide a service, but maintaining this element of voluntary nature of that service and cooperative nature of the agreement. The parent or the holder of parental responsibility is not required to accept that offer of the service. And the correct way, we say, to read section 20 in terms of the interplay or the dynamic between section 21C and section 27 particularly, is that there is a duty arising, but it is subject to limitations. And the limitations, we say, allow a parent to object so that the child cannot be accommodated. Now, a helpful way perhaps to approach this, and this was the approach of this court in an earlier decision in G versus the London Borough of Southwark, was to approach section 20 as posing a series of questions. And perhaps if I could invite the court to look at that decision, and in particular the judgment of my lady, Lady Hale. That decision is at Authorities Volume Tab 1, Authorities Volume 1, Tab 14.
Sorry, which MS number?
It's
The judgment begins at MS 284. And the paragraphs that we would like to take the court to are at MS 294, paragraph 28. And my lady here was importing a list which had been set out earlier by Lord Justice Ward in the Croydon case in the Court of Appeal, which was a case concerning an unaccompanied asylum seeker. And he set out a list of questions which a local authority had to ask when considering accommodating a child. And of course, it's helpful to consider that in the context of those particular cases where local authorities were not accepting their responsibility, which is different, obviously, to this case. But the list is set out: is the applicant a child? Is the child in need? Is he within the local authority's area? and so on, down to paragraph 5 on page 295, the 3 questions that are posed, and then my lady referring back to the decision of Lord Hope that a wide construction has to be given to the provisions of section 21C, and in particular to the term prevented, so that children do not fall outside of the local authority's duties, particularly in the context of those children. And then it goes on to refer to section 26, the views of the child. My lady has made the point earlier, my Lady Hale, and it's made, we say, very forcefully by the Quorum Children's Legal Centre in their document, that there's no account or representation in this case at all of the views of the children having been taken at the time of their accommodation. But the 2 matters which were not addressed in the Southwark case were items 8 and 9 on the list of Lord Justice Ward, that being the position of a person with parental responsibility in terms of an objection, and the entitlement of a person with parental responsibility to remove a child from local authority care. Now, what that approach assists with is the framework for the decision that is to be made by the local authority. In other words, that it doesn't end at the point at which the local authority decides that it has a duty to provide care and accommodation for a child under section 21C or under section 24, that it must ask the question where there is an active parent with parental responsibility, does the parent object? And that is the consequence of section 27. And there is a difference, of course, between A and B, where the person with parental responsibility cannot be found, and the active parent, who is a holder of parental responsibility.
Where do we find items 8 and 9 on
The-
Lord Justice Ward's list?
Yes, the judgment of Lord Justice Ward in the Croydon case is at tab 7, MS 100. And the list is MS 134, paragraph 75 of that judgment. Item, it's MS 135. Item 8 is, does any person with parental responsibility who is willing to provide accommodation for him object to the local authority's intervention? And 9 is, if there is an objection, does the person in whose favour a residence order is in force agree to the child being looked after?
So is there a slip in 8, Ms. Fontrell?
Well, my lord, it doesn't import the able provision. It simply refers to willing.
So is there a slip in 8?
Look, we have always, on our side, just say we have always felt there must be a slip there.
I'm asking
just to
Fontrell,
make that
and
comment
I think,
at this point.
I think there must be. You must accept that, Ms. Fontrell, don't you?
My lord, it's yes and no,
Very well.
if I may.
Very well.
The issue of whether somebody is willing would seem to be more straightforward on the local authority's case than if they are able. But, my lord, I can't say that it is, because it isn't explained why that term is excluded.
Okay, thank you.
Was that in any way an issue in this case? I don't think it was it?
No, this was a case, again, about unaccompanied asylum seekers.
Yeah.
So 8 and 9 were not
8 and
material
9
issues.
may have been in the list, but they weren't actually issues. So one can't attach too much importance to how they were phrased in that case.
They weren't material issues, and of course they weren't material issues in the Southwark case either.
Which is no doubt why they weren't referred to.
So
I can't remember, but I guess that would be the case.
So, my lords and my ladies, could we
But
move on?
the Lord Justice Ward is talking generically about decisions under Section 20, isn't he?
He is, and he's looking at the exercise.
He's not refining it to the facts of the particular case. He's going through Section 20. And at 8, he's dealing clearly with the subsection 7
Yes.
inquiry. Anyway, there it is, Ms. Vaughan.
Yes. Could we go on then to look at the question of how Section 27 is to operate? And there are a number of points that we would make in relation to how Section 20 is to operate. First of all, could I very briefly look at the statutory guidance in relation to Section 20 and what that tells us about how Section 20 is to operate? And that is to be found at Authorities Volume 7, MS 2093. That's tab 79. And there's a number of brief points I want to make and a number of points to bring the court's attention to. First of all,
What's
the
the
bottom,
MS number, please?
MS 2093.
2093.
Yes.
I must have failed to hear the 0.
At the bottom of page 2093, in relation to the provision of accommodation, you will see that the guidance refers to the intention of the Act being that accommodation is to be provided as a service under voluntary arrangements with children, with parents, forgive me.
Sorry, I haven't quite found that.
It's
The bottom?
MS.
224.
Oh, yes,
Yes,
provision of accommodation, yes.
Yes. So clearly setting out that the intention is for it to be voluntary and the voluntary element of it to be set out in the arrangements. 2.25, the Act assumes a high degree of cooperation between parents and local authorities in negotiating and agreeing what form of accommodation can be made. Sorry, forgive me, can be offered and the use that can be made of it. There is repetition of the point in the white paper that there's no provision which allows a local authority to take over parental rights. Therefore, parents are able to remove a child from accommodation whenever they wish to do so. Paragraph 2.26 makes the point that there's no distinction between pre-planned short-term placements and longer-term provision of accommodation. And then it goes on to say, in every voluntary arrangement, the service should be based on a voluntary decision by the parents to take up an appropriate service on offer and continuing parental participation in and agreements to the arrangements for the child.
This is the original statutory guidance.
It is, my lady, yes. Similarly, under the heading Nature of Arrangement, paragraph 2.27, in the provision of the service, the emphasis will be on partnership with the child's family so as to provide for the child's needs by voluntary arrangement. The next sentence goes on to say this is reflected in the provisions of the Act relating to service provision and voluntarily agreed arrangements. And again, when one goes on then, under the heading of partnership, down at the end of MS 2094, paragraph 2.28, partnership requires informed participation And paragraph 2.30, about halfway down that paragraph, it says when a parent is unwilling to cooperate at the outset or becomes uncooperative or inconsistent in attitude or commitment to the nature of the arrangement should be reassessed and the need for care proceedings or emergency protection should be considered. Now, the relevance of that when one looks at the provisions of the text of Section 20, we say is that it informs the interpretation of Section 20, and it continues that thread that we identified in the white paper, and it continues that conceptualization of Section 20 as having at its heart cooperation between parents and the local authority and a voluntary arrangement between parents and the local authority. And so when one looks to the text of Section 20 to identify and locate where the voluntary arrangement is to be found, we say that that must be found in Section 27 in the first instance at the point of provision of the service, and Section 28 during the currency of the accommodation if the parent changes their mind. It is a consistent reading of the provisions in light of the guidance that while the guidance uses the term voluntary arrangement, one finds that in the legislation in the provision on objection.
But the question really ultimately is, and I say this from a position of almost pristine ignorance, but is whether all of this background material infuses Section 20 with an aspiration to achieve agreement, or whether that imposes an absolute requirement. And I suppose the point would be, it could be made against you that if it was intended that Section 20 should impose as an invariable and immutable provision, that there be a requirement of agreement, that could have been very simply and explicitly provided for.
Well, my lord, to an extent it is provided for in relation to Section 28.
Yeah.
Section 28 is unqualified.
Yes,
so,
but why not in relation to the other subsections?
Well, what was envisaged, and I'll come back to this after the lunch and adjournment to answer the issue as to what mischief was being addressed by the introduction of willing and able. Willing and able doesn't introduce an evaluative test for the local authority to apply at the point in which it is satisfying itself whether a parent objects and whether that is an objection which prevents it from accommodating the child. Willing and able was introduced to the Act so that where you have potentially a parent who is absent or a parent who is a feckless parent, for want of a better word, that they cannot prevent a local authority from accommodating a child where the active parent has given their consent. In other words, that the objection of a parent who is on the other side of the world in Australia, who has no relationship with the child, who is not in a position to take over the care of the child, should prevent the accommodation with the agreement of the primary active parent. And the difficulty, my lord, is when one looks at the wording of Section 27 and compares it to the wording of Section 21C, it's revealing that the evaluative judgment is clearly present in Section 21 because it includes the term, it appears to them. And further, it includes the term that the parent is prevented, for whatever reason, from providing suitable care and accommodation. Both of those, or all of those phrases, we would say, indicate an expectation that the local authority undertakes an evaluative exercise The difficulty, and you'll see this in our submission, it's the essence of our case, is that in the absence of similar terms, if one introduces an evaluative judgment, which is to be made by the local authority, and overrides the views of the parent as to ability or willingness, that is not reflected in the wording of the Act, because it doesn't include "it appears to them," first of all. And secondly, it would allow the local authority to impose an arrangement rather than to reach an agreement, to, if you like, impose cooperation, or to enforce a duty against the clear objection of the parent.
Yep.
Suppose we see it completely differently for a moment and concentrate on the fact that anyone who has parental responsibility may at any time remove the child. So you could postulate the situation in which the child goes into the local authority's accommodation in minute 1 and in minute 1.5 is removed. So the Act is contemplating a veto from the parent. Maybe the contemplation of the Act is that the child won't get there into the accommodation at all if it's all really just an unsaid part of subsection 8, because they won't even start in that accommodation if at the start the parent is not willing for that to happen. And you don't need, therefore, to look at subsection 7 to get that out. If those are what the local authority is enabled to do, and 8 is what the parent is enabled to do. So it starts at the point when the parent has already, well, they're not seeking to remove the child instantly.
Well, the only, my hesitation arises from the language of section 27, because when one looks at the language of section 27, it is before providing accommodation. And what we say this court needs to clarify is the correct interpretation to be given to that subsection of the Act, as to what the nature of the local authority's responsibility is before the duty and, if one likes, the offer of accommodation is taken up. Now, in practical terms, to take my lady's point a little further, there was nothing, for example, to stop, in this case, Mr. and Mrs. Williams signing up to an agreement, going through a revolving door and coming back and withdrawing their consent, to use that terminology. And if one looks at that as the operation of section 27 with section 28, you have this nonsensical situation in terms of the practical realities. But the question is, what is the obligation of the local authority? And the local authority, we say, on the terms of the Act, because of that specific inclusion of before providing, clearly envisages the question being asked, is there a holder of parental responsibility who is actively parenting this child, and does that person object? And is that person willing and...
Well, that's before providing's in 6, not in 7, isn't it?
Yep. But it says a local authority may not provide.
Yeah.
So it's part of the exchange.
Well, provide is a continuing activity, isn't it?
Well,
so you may not begin to provide, obviously, in those circumstances. If they do, equally, you may not continue to provide.
Yes, it's slightly different, the language in section 28, because it says that the parent can, or the person with parental responsibility may remove the child from accommodation provided. So
there's a perfectly simple point of view which says that subsections 1 to 7 inclusive are dealing with the local authority's powers and duties, and subsection 8 is dealing with the parents and what they can do.
My lady, I'm hesitating.
I think that's the Association of Lawyers for Children's construction of this statute, and that's one way of looking at it.
Well, my lady, I think the slight difficulty with that is that it lacks clarity as to the extent of the local authority's responsibilities at the point of provision. If the reading of section 27 and 28 is going to be that the decision to provide is a continuing state of affairs, there is still the question of, before the children are accommodated, is the local authority required to satisfy itself as to the status of any objection? Well, whether there is an objection.
But what's wrong with them having to do it at the outset and later on?
Well, the legislation, we would say, requires them to do both.
Yes, well, I think that was what was being put to you.
Forgive me, I may have misunderstood.
You seem to be confining subsection 7 to the point at which the child was first accommodating. And I was simply putting it to you that the word provide is a continuing state of affairs, and so subsection 7 would apply not only at the outset, but throughout the accommodation.
Yes, my lady, I have no difficulty with that point.
I would also agree with that, subject to the fact that subsection 8 usually takes over after provision has first been made.
Yes, and that certainly accords with the text. May I just deal then with the question raised by the local authority as to, or the question posed by the local authority as to whether or not the local authority has a power under the Act to adjudicate on or determine whether a parent is able or willing. And I'll deal with this point, if I may, by looking at my Lady Justice Black's judgment in the case of Re B, and that is in Authorities tab 1, MS 355. And the discussion begins at MS 361, paragraph 32. Now, it's right to say, of course, that these comments were obiter in the context of this case. The issue in the case was whether or not a child had been accommodated by the local authority with a grandparent. And one of the reasons why the court reached the conclusion that the local authority had not in that instance accommodated the child was because of the persistent objection of the mother. And then at paragraph 34, my lady sets out, I raised the question during the appeal hearing as to whether a parent who is inadequate is in fact willing and able to provide accommodation. And my lady went on to record a common understanding that where parents in fact object to a local authority providing accommodation, a local authority will have recourse to care proceedings if they seek to accommodate a child, and any debate as to whether the parents are able to provide accommodation is to be had in that context and not in the context of section 20.
Fair to say that the passage you missed out was that it didn't excite much argument.
Yes, I see that. Yes. Well, my lady, here we are. I see. My lady went on then to look at paragraph 35 and to set out my lady's analysis that the duty arose under section 21C. In that particular case, the local authority prevented from fulfilling its duty, and my lady positing the alternative that the joint effect of section 21 and section 27 in that case was to prevent the duty from arising at all. Now, the 2 points I would make very, very briefly about that are if there is a material or a factual dispute between parents and the local authority as to the substantive reasons for accommodation, as there were here, then we say the scheme under the Act envisages that dispute being resolved under Part 4. The alternative to that is the local authority's suggestion that the local authority is entitled to assess the ability of the parent, and the challenge to that is judicial review. There are a number of difficulties with that. First of all, that you have different tests being applied in different parts of the Act. So you have a different test in Part 3, Section 27. Is the parent able? As opposed to the test in Section 31(2), is the child at risk of significant harm? But also that you have a remedy in judicial review which cannot resolve the factual dispute and which falls outside of the scheme under the Act. Where there is a factual dispute, the local authority must, in the face of the objection, the lack of agreement, the lack of cooperation, make an application to court.
But isn't this issue about willing and able, who decides, rather academic, Ms. Fottrell? Say a local authority say, no, you're not willing and able to provide accommodation. Therefore, whether you object or not is quite irrelevant under Section 7. Then the parents say, well, okay then, subsection 8. We want the children back. We're going to remove them. So that's why I ask whether there's any practical reality about this issue.
Well, my Lord, I suppose the point that we would make is there was a practical reality in this situation, because the local authorities read of it, first of all, read of the circumstances on the ground, was that the parents were not able because of the state of the home, but also that they were not able because of the bail conditions.
Yes.
And those realities were contested by the parents. So I accept that one takes the next step, which is the revolving door point, that the parents simply come back and say, we don't agree any longer, if we agreed at all. But if a local authority is going to properly deal with the issue of parental objection under Section 27, it doesn't have the entitlement to override the parents' assertion that they are able, if that is leading to a factual dispute about the substance. My Lords and Lady, I see the time. Shall I pause there?
Sounds like a good place at which to pause. Thank you very much indeed. We look forward to hearing from you further at 2 o'clock.